I recently uploaded a video in which I discussed the process of being arrested, detained and interviewed by police in the UK, detailing everything I could think of from what the police must do when they arrest you, to what happens at the custody desk, what it's like inside a police cell, the food options, what happens when you're released, and a few of my own experiences. You might be thinking, well, that's never going to happen to me, but these days all you have to do to find yourself in the back of a police van is look at a copper the wrong way or post a slightly off-colour tweet. Those who never expect to be arrested will probably be those most shocked and stressed by the experience and ill-prepared for it. So if that's you, check out the video, which I'll link in the description. Whilst making the aforementioned video, I put out a post asking if there was anything in particular you'd like me to cover. There were quite a few questions and comments which would have made the video too long, so I decided to make another one responding to those. So first off, a few people either claimed that or asked if saying "I don't understand" is a good response to police questioning. In my view, if you speak English sufficiently and are mentally competent, then it's a really bad idea to pretend not to understand. I mean, how long are you going to keep that up? The police are stupid, but not so stupid as to believe that Kevin from Whitby, with a full-time job, a wife, a mortgage and 2 kids, doesn't understand basic questions like "where were you Friday night?" All you're going to do is make yourself look dishonest and bring your credibility into question, which could work against you if the case goes to court. Not only that, but if you persist with the pretense, you're likely going to significantly increase the amount of time that you're in custody. When it comes to vulnerability, the police have safeguarding obligations and can't just dismiss your repeated assertions that you don't understand anything that's going on. I'm not particularly au fait with these procedures, but it's my understanding that if you give the police cause to believe you're vulnerable, they have to bring in an appropriate adult, a relative, social worker or volunteer from the appropriate adult scheme, which will only delay matters whilst they source and await the arrival of a suitable person. In some circumstances, they may also have a custody healthcare professional assess your mental state to decide whether or not you're fit for the interview. If you manage to convince them that you're not, the interview will be delayed until you're deemed fit, or it may be abandoned entirely. Even without the interview, you could still be charged, and in the highly unlikely event you manage to convince medical professionals that you're not fit to plead, the court could proceed with a trial of facts and you wouldn't be able to give testimony in your defence. Of course, if you genuinely don't understand the alleged offence, the police powers or the questions they're asking, you should seek clarity. But I advise asking for the interview to be paused and speaking to your lawyer for advice as opposed to the police. MJ commented saying the only question you should answer is about your mental health and firmly state that you're of sound mental health, otherwise they'll go down the mental health route when you don't comply. The police are nasty, Machiavellian types with no compunction and no depths they aren't prepared to stoop to. There are many ways the police could use your mental health against you, for example, reporting you to social services with feigned concerns that your conditions affect your parenting enough to warrant state intervention, to undermine your reliability as a witness, to justify using force against you, to paint you as unstable, etc. So yes, I agree, this is something that you have to consider when deciding whether or not to disclose any mental health conditions. I usually do disclose my conditions because for various reasons I don't feel overly concerned about the police being able to weaponise my mental health against me, and I feel it's important that they consider my conditions when carrying out detention reviews, and when making discretionary decisions such as allowing me to have phone calls, get fresh air, and have distractions such as books and writing material when I ask for them. They either treat me appropriately, thus making my time in custody slightly less unbearable, or they face a complaint and possible legal action, unable to deny knowledge of my needs. Whether or not you disclose any mental health conditions is personal and highly situational and something you should give good thought to. Which leads me to another consideration raised by Noza, who said that when you're in custody and they ask if you have mental health conditions, if you don't answer, or of course if you confirm that you do, they could take your clothes away because you might harm yourself. It's never been my experience that on merely divulging mental health conditions they've taken my clothes away, but every custody suite is different and there doesn't seem to be much consistency. For example, some custody sergeants have been really anal about making me hand over anything that could possibly be used to self-harm, including jewellery and even hair ties, and others haven't even mentioned them. I do always let them know that I have no intention of self-harming, and sometimes that's enough for them to let me keep such items on me. There have been 2 occasions when my clothes were taken off me, once by force, as mentioned in the previous video, and the second time under the threat of force. Unsurprisingly, both incidents involved Norfolk police. The second incident serves as a good example of both what not to do in custody and how you shouldn't be treated by police in custody. So I'd been locked up and detained for hours and treated very badly. Without combing over my records, I can't remember which specific arrest this was, but like pretty much every one of my arrests by Norfolk Constabulary, it was malicious, personally and politically motivated, and unlawful. I wanted to speak to my solicitor about my treatment and had been asking for a good hour, with staff completely ignoring my request despite it being illegal for them to deny. As they were refusing, I decided to press the cell buzzer repeatedly until they granted me a call with my solicitor, but they just didn't answer. I was getting increasingly angry, and I mean like PTSD rage angry. It's hard to describe the feeling of helplessness, frustration, and injustice when you are, time and time again, locked in a tiny room, completely cut off from the outside world with no idea how long for, whilst at the mercy of soulless tyrants who take pleasure in dehumanising you, and when you know you shouldn't be in there at all. When they stopped answering the buzzer, I began waving at the camera, kicking and hammering on the cell door until my knuckles were bruised and bloody, shouting, but still no one came. After exhausting all options, I did the only thing that I knew would get them there in seconds. I took off my police issue sweater and tied it around my neck, just an overhand knot, and sure enough, multiple detention officers arrived immediately. So they'd obviously been watching me on the camera, were well aware of what I wanted, and were simply tormenting me for their sick pleasure. They instantly demanded that I remove all of my clothes, and I told them I had no intention of harming myself and was just trying to get their attention, seeing as they'd unlawfully denied me access to my solicitor for the last few hours. But they were having none of it. I refused to take my clothes off, and one of the detention officers, one I'd encountered many times over various days when I got the impression was well aware the police were unlawfully targeting me, looked into my eyes almost imploringly as she said, "Please, Gemma, just take them off or it'll be done by force." It was obvious that she knew it was completely wrong, but she was too spineless to speak up. There were 2 other female DOs behind her, one built like a brick shithouse and another nasty looking bitch who looked like she would very much enjoy it. After more calm protestation about my intentions, it was clear they weren't going to listen to reason, as people who blindly follow rules and love to inflict suffering on others. It did get me my phone call, but a better way of getting their attention would have been to put the sweater down the toilet and repeatedly flush it to flood the cell. Then we have a few questions and comments about food. Eric Blair asked, how do they deal with nutrition requirements? I did cover this in my previous video, but to further clarify, this is set out in PACE Code C, which states at least 2 light meals and 1 main meal should be offered in any 24-hour period. Drinks should be provided at meal times and upon reasonable request between meals. Whenever necessary, advice should be sought from the appropriate healthcare professional on medical and dietary matters. As far as practicable, meals provided shall offer a varied diet and meet any specific dietary needs or religious beliefs the detainee may have. The detainee may, at the custody officer's discretion, have meals supplied by their family or friends at their expense. Of course, what's considered practicable is subjective and open to abuse, but if you have any specific dietary requirements, the police should cater to them. If for whatever reason they can't, then they should definitely allow friends or family to bring food in for you, since that is undeniably practicable. Charlie Pierce said, when given food, I prefer my own spit in it rather than a stranger's. Be careful of anything you consume. And echoing that sentiment, Ghoulish Ghoul said, if you're unfortunate enough to be arrested and held in custody, my advice is never accept food or drink from the police, not even water. They will definitely tamper with your food and beverages. I have certainly encountered DOs I think would spit in my food, and others I just can't really see doing that, so I guess it's a judgment call. When it comes to water, every cell I've ever been in, bar one, which I think may have been a London one or maybe one in Scotland, I can't remember, has had a sink with drinkable water. So you just get a cup and can fill it yourself. They usually offer tea, coffee, hot chocolate, and herbal tea, which they make. So again, maybe avoid those if you do think the DO is verminous enough to spit in your drink. If you ask for a microwave meal, it's likely they'll peel or pierce the plastic film, but I have on occasion asked them not to do that so that I knew the food hadn't been tampered with. Avoid a pot noodle if you're concerned, as they obviously can't make those without peeling the lid, but the fruit pots are sealed. Again, if you're really concerned, you can tell them this, and it gives you good grounds to argue they should allow sealed food to be brought in by a friend or relative. A few of you asked and commented about the duty solicitor. Jamie said, sad that you've had so much experience of bad policing, is there any other kind? And asked if I've ever used the duty solicitor. Yes, quite a few times. My solicitors, being so far away when I was in Norwich, have often instructed the duty solicitor to represent me at the police station, whilst maintaining phone contact and giving limited advice, mindful that although the conversations should be private, you can't trust the police to follow the law. I've never had any bad experiences with duty solicitors at the police station, but I have at court. She was horrendous, but that's a story for another time. IR Disco said, trusting a duty solicitor is a significant risk. They haven't elaborated on why, but I can imagine and agree it's not the best choice. I've seen duty solicitors being really pally with the police on first name terms, and there's a risk of conflict of interest when they see these same officers so often. A good solicitor will always put their client's interests first, but it's something to be mindful of. You don't know who you're going to get, as it's whoever's on the rota. They don't get paid that well and may be juggling a lot of cases. It's worth noting though that duty solicitors do not work for the police. They typically work for local law firms and are like any other solicitor but have completed an extra qualification to join the duty solicitor scheme funded by the legal aid agency. Rachel asked, if you use the duty solicitor while in custody, are you entitled to free legal representation at court? Representation at the police station is always free, but it doesn't automatically entitle you to free representation at court. You'll have to find a solicitor that does legal aid work, which is increasingly difficult given the massive cuts, as it really doesn't pay. Once you've found a firm that does take legal aid, they will typically apply for funding from the legal aid agency on your behalf. You will only be granted legal aid if you're on benefits or a very low income. If you're denied legal aid, you can apply for a hardship review if you can demonstrate that paying privately would cause significant financial hardship. This review gives you more scope to detail additional outgoings that aren't considered when first applying for legal aid. Crown courts don't have duty solicitors, but magistrates' courts do, and their services are free but very limited. They will provide legal advice and sometimes representation to those who don't have their own solicitor. They generally only represent defendants at their first hearing, for bail applications and plea hearings. David Smith said, I'm fascinated by the offer of a lawyer, who lawyers are, whether they are competent, and whether they genuinely advocate or fold to compromise to your disadvantage. Every lawyer is different in terms of personality, background, ability, and approach, so it's hard to answer who they are as a collective, but if I was pressed, there are a few traits I've noticed are perhaps more common in specifically criminal defence lawyers, as they're the ones that I've spent most time with. They tend to be cautious, composed, analytic, intelligent, highly focused and driven. I think I've just been extremely lucky in that I've had an excellent defence team in Kelly's, the firm that I've always used, and the barristers that they've instructed. They've been an absolute godsend and worked so hard, going above and beyond and never letting the woefully inadequate legal aid system impede the quality of service they've provided. The lawyers I've worked with are kind, compassionate and have a strong sense of justice and recognition of just how messed up the judicial system is. I've never felt any of my lawyers have folded or compromised to my disadvantage. They've always explained and discussed everything with me. Ultimately, you're the one instructing the lawyer and they can only advise. Most of the time I've taken the lawyer's advice, but there have been times where I've not. For example, recently choosing to run protest as a defence despite my solicitor advising that the court would not look favourably on it. I think her advice was right, but I did paint the police cell with lasagna out of protest, as well as mental distress at being unlawfully arrested and confined, and I wanted to stand up for my actions and my right to protest. Neil G said of being in custody at a police station, you are supposed to be able to have access to a private telephone call with a lawyer. Often cops stand next to you, which is against the law. Yes, you do have to be careful. Any discussions with your lawyer should be completely private and confidential, but you can't put anything past the police. I don't recall having them stand next to me when I've been on the phone to my solicitor, but depending on where I've been, which custody suite, they've always brought me to a room with a phone, brought a phone to my cell, or more often, put the call through to the cell via the intercom. My solicitor will always remind me to be careful of what I say in case they're listening. No one knows how slimy and bent the police are, quite like a defence lawyer. Judith asked, do the police explain the charge or just name it, e.g. harassment? Do they allow reading material in your cell? Do they tell you how long you'll be in there? And how long, if you don't want the duty solicitor, is it before you get access to your own? In my experience, they usually don't explain the offence in any great detail, just name it. Your solicitor should elaborate on the legislation so you understand why the police phrase the questions the way they do and the elements of the offence they will be trying to prove. Yes, generally they do allow reading material in your cell. On some occasions when I've knowingly taken arrestable action, e.g. locking on outside DEFRA HQ in London or occupying places of animal abuse, I've brought my own books. As mentioned in the previous video, they'll also likely have books, magazines and puzzles available at the station. No, they don't tell you how long you'll be in there. The custody police and staff are not any part of the investigation, so they don't know at what stage the investigating officers are at, but you can ask them to get in touch with the OIC, the officer in the case, for an update. If they can be bothered, they'll come back to you and say the interviewing officers are on their way, they're still preparing for the interview, etc. But take whatever they say with a pinch of salt, because many times I've been told, oh, they're about to interview you, and waited another 5 hours. If you don't want the duty solicitor and ask for one of your own, how long it takes for them to arrive depends on a lot of factors like where they're based and how long until they can get to the police station. But for me, it's been rare to be waiting on a solicitor rather than the police. MKH Nitro said, never ever say a word in interview. Don't give your name, don't say no comment, don't acknowledge your presence in the room. Your solicitor/legal executive is obliged to acknowledge their presence and identity. You are not obliged to say anything. Absolutely, I've covered the pros and cons of various interview strategies in my previous video. Again, if you haven't seen it, the link is in the description. But this is generally the exact approach that I would take. David said, as the local police clearly know you, it would be obvious to them that you display a consistent pattern of behaviour or, from their point of view, pattern of criminality. Following arrest, has this familiarity altered their behaviour in any positive way? I suspect not. I appreciate the time and effort you've invested into making this video. Thank you, David. Firstly, I don't believe for a second that the police believe the vast majority of actions they've tried to penalise me for have been criminal. They just hate me for defending animals and repeatedly exposing their force for the cesspit of abuse and corruption that it is. Every officer who's arrested me in Norfolk has seemed to know who I am or soon found out and made comments alluding to that. This has far more often worked to my detriment, with the police treating me with more contempt and making it very personal. Being known to the police as someone who doesn't conform, hates and exposes the police, and stands up for others is never going to work in my favour, and I genuinely can't think of an example where it has, other than a pretty insignificant one where a female officer refused to take my handcuffs off when there was no justification for them being on. I looked her dead in the eye and told her that if she didn't remove the cuffs, I would sue her in her personal capacity. She didn't say another word, just took the cuffs off. That may be attributable to her knowing my history and that I do go all out to hold the police to account, and I'm not afraid to file lawsuits against them. John said, really good work, but I spotted a mistake. The 24-hour custody clock doesn't start at arrest, it starts at custody. If you are wanted in Birmingham and arrested in London, the travel time is not part of the 24 hours. It starts when you are at custody in Birmingham. Thanks very much for pointing that out, John, and you are of course right. I remember asking a lawyer how much longer she thought I would be in custody, and her saying something like, it can't be long now, you were arrested at whatever time yesterday, and I misconstrued that to mean the arrest time started the custody clock, when really she was probably just pointing out how long I've been detained for. I've amended the original video, but just wanted to correct this for anyone who was misinformed. Scott Saunders said, I was wondering what they might do if you're a wheelchair user. I had a mate with spina bifida. He was dragged through his car window at gunpoint, dragged along the floor, arrested and dragged into a police car. They refused to let him take his wheelchair, telling him, "Your wheelchair is a weapon." I was arrested when I was 18 and handcuffed to the front. They took my wheelchair off me once in the cell. Once they figured out I was innocent, they let me go, saying, "We'll see you again soon." They refused to let me speak to the AMBO service or my family, as I take many different drugs. Luckily, I wasn't on oxygen then. I've never had an apology. I made a complaint. They looked into themselves and found they did nothing wrong. Ugh, aren't they just repulsive? No humanity in any of them. Off the top of my head, I can think of at least 3 wheelchair-using activists who've had similar experiences when arrested. Well, not as extreme as being dragged through a window at gunpoint, but still very badly mistreated. Disabled people are protected under the 2010 Equality Act, and the police have to give consideration to and make reasonable amendments for a person's disability. I would suggest that anyone in a wheelchair who finds themselves under arrest promptly makes the police aware of their disability and requirements for mobility, moving and handling, and speak to a solicitor if they feel the police are being discriminatory or not making necessary adjustments. Lee James said, "Non-payment of the TV licence, that's nothing to do with the police. They can't get involved in that. I haven't had one for years and I'm not bothered about arrest. Can't hold you for not wanting to pay the BBC, completely legal to not have one." Anyone who watches live TV or streams on BBC iPlayer without a licence is committing a criminal offence under the 2003 Communications Act. I've never paid the TV licence and never will, no matter how many dozens of red final letter warnings they send me. If anyone from TV licensing comes to your home, you can ignore them, you don't have to let them in, and you're rightly, it's not something the police get involved in. I just used that as an example of a non-recordable offence. Another question from David, who asked, charge stacking to intimidate. Do they threaten additional charges to try break your resolve and then never mention them afterwards? Pardon me if my questions seem naive or simplistic. Not naive or simplistic, it's a good question, and had I thought to, I probably would have covered this in the first video. Yes, the police are renowned for charge stacking. I call it throwing shit and hoping some of it will stick. I remember being in a cell in Norfolk and police coming in at least twice to arrest me for further offences, and when I was arrested in Peterborough, I was told that after they'd finished with me, I was going to be transported to Norfolk because the filth there wanted me for alleged offences in Norwich. My solicitor, duty I might add, managed to persuade them against this, and if I remember correctly, the police in Peterborough further interviewed me on behalf of Norfolk Constabulary. All the allegations from both forces were dropped, but I was convicted of a public order offence for saying hurty words to the Peterborough cops who'd arrested me at court moments before my friend was due to stand trial. I have just 2 public order convictions, and both of them are from my reaction to being unjustly arrested for alleged offences I never even stood trial for. Without checking, I would guess that around 70% of the alleged offences I've been arrested for I've either not been charged with or were dropped by the time the case got to court, leaving just 1 or 2 of the original charges or a lesser one. The police pile on the charges to intimidate, and in the hopes the defendant will plead to or be found guilty of at least some of the charges or accept a plea deal before trial. They also want to give the judge, jury or magistrates as much scope as possible to convict. Not only that, but they want to build a defendant's record. Even if charges are dropped or later merged, they will still show on the P&C and can affect how someone is treated if they're arrested again. For example, when I was unlawfully arrested for breaching bail conditions the court had rescinded, the police accused me of smacking a police officer over the head with my handcuffs. This allegation was dropped because there was no evidence. I think before charge, but either way, it didn't go to court. When I was arrested by another officer more than a year later, he cited my history of assaulting police officers as necessity for using handcuffs. Another benefit of charge stacking for the police is bolstering their reasoning for denying bail or adding onerous and restrictive bail conditions if they do grant bail. David also asked, how do they modify their methods/approach if you declare a straightforward health issue? I mean, anything from lack of fluid intake affecting concentration to hunger or anything else, if at all applicable. I recall Pinaki News being arrested and needing medication but being denied it. Revealingly, he rarely goes out filming anymore. In my mind, it's likely that he was intimidated into partial retirement. In my experience, they don't modify their approach to meet any needs associated with your health issues. They just don't care, as the vast majority of times there are no ramifications for their negligence. As previously mentioned, they are required to provide food and water, and they should ensure you have any medication that you need. If you have the medication on you when you're arrested and it's in the original packaging with the prescription on it, they're more likely to let you have it. If you don't have the meds on you, or you do but it's just a blister packet with no box or prescription, they should have a healthcare professional see you and confirm what medication you need and the dosage by contacting your GP or having a friend or family member bring in the medication with the prescription on it. But again, I've heard so many accounts from people who've been denied vital medication by the police. My housemate and fellow activist Jamie was denied his SSRIs on 2 occasions whilst in police custody, despite me and other friends repeatedly calling in to say how crucial it is that he took them, and Jamie himself repeatedly asking. It can be extremely dangerous to suddenly stop taking SSRIs, and on both occasions it caused Jamie to experience profound mental and physical withdrawal symptoms. On the second occasion, when he was kept over the weekend for alleged breach of bail, Norfolk Constabulary told both me and a staff member at Norwich Magistrates Court that Jamie had been given his SSRIs when he hadn't, an outright lie. It's really no wonder there are so many deaths in police custody when this kind of gross negligence is completely normal. KW asked, what does it mean about necessity for arrest when you're asking about grounds for arrest? A lawful arrest by police requires satisfying elements of a 2-part test. Firstly, the police need grounds for arrest, so a genuine and reasonable suspicion that the suspect has committed, is committing, or is about to commit an offence. And secondly, that the arrest is necessary, for example, to prevent the person committing further offences, to obtain evidence via questioning, or to obtain the person's details. It's not always necessary for an arrest to be made even if a suspected offence has been committed. For example, if someone was suspected of committing a low-level offence, the police would have grounds, but if they knew who that person was and where they lived, if the police witnessed and recorded the alleged crime and thus had enough evidence and or the suspect agreed to come in for a voluntary interview, and if they were unlikely to commit a further offence, arresting them may not be necessary. But the police will almost always find a necessity for arrest just because they love getting a collar. CW asked if stopped because an officer considers your actions suspicious and then asked by that officer what you're doing, are you obliged to answer, and what might be a suitable, non-antagonistic response without giving them details? I think that's highly situational, and it really depends on what you're up to and whether or not it's genuinely suspicious. But of course, the police will always look for a reason to harass and exert power over members of the public, and if your conduct is perhaps unconforming or unusual but lawful, for example, filming a police station, I would just fire questions back to put them on the back foot, first asking them to identify. You could ask them if they're prone to paranoia. Am I doing anything illegal or just something you don't like or find unusual? Don't you have anything better to do? And then maybe quote some of their shocking solve rates as an example of what they should be focusing on. You could point out, if applicable, that they haven't informed you they're recording you on their body-worn cameras, as their policy requires they do. Or you could tell them that they're making you suspicious because it's weird to accost strangers. Let them know that you're clued up on your rights and not an easy target, and ask them to articulate their suspicion. No crime, no ID. Of course, you could just say absolutely nothing, which they seem to find very perturbing. Bear in mind that anything that isn't blind obedience and reverence for their inflated sense of self-importance, and any questioning or challenging of their authority, will be antagonistic to them no matter how polite you are. Joseph Benoit mentioned the slow and timely process of investigation and detainment. Everything is on a snail's pace. Why? I suspect that was a rhetorical question, but yes, it's completely unjustifiable. If they're going to arrest someone, they should have their shit together, evidence ready to present, interview questions prepared, and interview the suspect right away. I don't see how a suspect languishing in a cell is necessary for an investigation at all, but of course it's just to intimidate and demoralise. I saved my favourite question for the end from Peter Williams, as much detail as possible about the process and anything you noticed that annoyed the police during this process. I think I provided as much detail as I could in my previous video, but as for things that annoy the police, there's always more to be said there, and you're definitely asking the right person. Right at the top of the list has to be telling them how to do their job. They hate that. It undermines them and dents their egos massively. They get annoyed when you don't answer their questions in interview, they don't like it when you press the intercom repeatedly, and they definitely don't like it when you flood the cells and cover them in lasagna. They don't like it when you're neither scared or respectful of them. They hate it when you refuse to walk to the police van, as if there's only a couple of them, they'll need to call and wait for backup. Even worse, when you get to the station and also refuse to walk to the custody desk. The arresting officer must stay with you until you're booked in, and in refusing to walk, you can delay them from either going off to bully someone else or from going home. They absolutely loathe being filmed and, even worse, posted online. You only have to look at the lengths the police have gone to stop me doing this to see how completely intolerable this kind of accountability is for them. So that's all the questions. I did try to answer all of them, but apologies if I missed any. Thank you for watching, and please remember to subscribe and check out my other videos for more similar content.